thank you everybody for coming along today to May's Contentious Clinic. We haven't done a live session for a month or so now. The last one we did was actually recorded by Eleanor, and that is on the IDR interview. But we're back and we're running live sessions now from May. So it's great. It's great to see you all here. And thanks again for joining. Just admitting some more of you now. It's getting full. Today, Martin Holdsworth, CEO and founder of IDR Law, will be presenting for us. And he's going to be talking about how to avoid contentious probate and how to generate fees from it. And I'm sure he's going to give you lots of practical tips along the way and things you can take away and use in your day to day. So I will hand over to Martin now, and thank you.
Thanks, Lindsay. I'll say good afternoon to everybody, even though I can't hear or see anybody at the moment. So I'm assuming you're all saying hi and waving. I'm the founder, now CEO of IDR Law. I can see lots of the names through that I actually know, some of you, which is always lovely for coming back. And also those that I don't know, it will be great to meet at some stage in the future. Just by way of introduction, if you allow me, for those that don't know me, I personally dealt with my first contentious probate case, back as a trainee solicitor in 1993. And in fact, I'm slightly embarrassed to say I was actually described as an article clerk. I was the last year that was actually a thing. And for the last 20 years or so, I've been dealing exclusively with contentious probate and nothing else. So lots of change. In fact, when I did my first case, it wasn't even called contentious probate. It was just a dispute about a farm, and I've been doing it ever since with a farm, and nobody knew what to do with it. So it landed on my desk because I was a divorce lawyer that did a bit of litigation. So that was my background. I sit on the ACTAPS committee. I'm Band 1 Chambers, Legal 500, Hall of Fame, blah, blah, blah. Got all the badges and all the rest of it. I have to say I'm also a Yorkshireman. I'm dad of 4, husband to an amazingly strong wife who survived a brainstem stroke at 38 when all the kids were under the age of 10. So I have to say nothing I do at work stands up at home. So I keep very grounded at home and enjoy my time there. It also is a driving factor into how and why IDR Law was set up and why we run it the way that we do. I thought it might be useful, even those people who I know, who I haven't spoken to for a while, that give you a very, very brief update on what's occurring through IDR Law. And it's we obviously founded in 2017, so that's nearly 7 years ago now, come October time. We're now 24 strong, starting from a standing start. And of those, we've got 18 lawyers. Fee earners at different levels. We've got partners, we've got senior associates, right through to paralegals that we take in through the university. So we do a sort of a scheme through there. Office is in Harrogate, just about to triple the size of that one in Manchester that's doubling, and we've got one in Bristol. Over the last 6 years, we've dealt with 7,000 inquiries. We've triaged every single one of them. We have a triage centre that we run to make sure that whoever refers a client or however they get there, they are triaged by the same team. And we, on average, accept 21% of those as actual clients. The remaining 79% of them are signposted to where they can get help elsewhere or explain why they don't have a case and perhaps they should wait for the person to die before they actually come to see us. So we keep lots of data, as you can probably tell. My background's maths, physics, computer science, so I'm always very, very keen on numbers and tech. Last year was quite a big one. We completed a private equity minority shareholder deal, which saw 27.5% of the business move to BGF, or British Growth Fund. We also issued some growth shares to reward and to motivate the senior management team. So it feels slightly more corporate in structure, but still that same family feel. What the investment has allowed us to do is to gear up, and we've got some strategized growth plans we have over the coming years. The last 10 months, really inward focusing in so far as creating systems, in so far as creating tech that we wish to deliver. And we're all very excited because we're now at the stage where we can start to deliver on those pieces of work. We've got legal tech releases rolling out, which I'm going to talk about in a minute, and we've got new people coming in. So we're looking to sort of triple the size of the practice in the next 3 years. And we've got 4 new starters coming in the next sort of 4 or 5 weeks, one of which started yesterday, a chap called Stephen Lawson, you may have heard of, who's a partner and is enjoying himself already after day 1. PE for us, really are the 3 red lines that were set in place, and they were very simple for me. One was that the growth of the practice was not going to be achieved by simply putting up lawyers' targets year on year. I've done that for 25 years, not going to do it now, I don't believe it works. Inwardly, everything we had to do to support the family culture that we've created was to continue and not change as well. And equally, we wanted flexible career paths and stick to our primary B2B process of marketing and getting work. So again, we were in a unique position and we wanted to maintain that going forward. That is a very, very quick whistle-stop tour, bringing everybody up to date. So we are where we are. We're sitting here with 18 lawyers to keep busy. Current capacities are pretty much at the top level as it stands at the moment, and we've got new people coming through. But that's not why you're here. Why you've attended is the clinic title is to know how to avoid contentious probate and how to make some fees if it happens. I've had a look. I always do this. I'm sure you do the same when you're doing a webinar, is that you ask to see the guest list or the attendees list of who's coming and who's attending. And it's so nice to see so many people that I know. I can see from the list that there's quite a few contentious probate lawyers on there as well. And I say immediately, you're absolutely more than welcome. Some of them are good friends. That's nice to see. I think for the rest of those on this call who are not contentious probate lawyers, I'm just going to have a little bit of fun with them, if I may, is that we will send a prize to whoever can come up with the best collective noun for a group of contentious probate lawyers. Put your answer in the chat, and by the time we get to the end of this in about 25 minutes time, I will judge which one I prefer the most. You can be as irreverent, but please don't put swear words in there, and we'll choose it. So whoever can come up with the best collective noun for a group of contentious probate lawyers, I will wing a prize, whether that's a bunch of flowers, or if you drink, then a bottle of something nice to have a drink over the weekend. So let that run alongside. Equally on the messages, by the way, on the chat, if you've got any questions at all about what I'm talking about or generally, please feel free just to drop it in there, and I will do my very best to get through them and answer them. And if I can't, then I'll follow them up after the meeting today. So what do we know? Well, we all know that contentious probate is on the rise. We know that, I suspect, mainly because the Daily Mail seems to have one story in every day. Today's Wills and Probate, I remember when that first started, there was the odd story. Now it seems to be at least one story every week, either a team being built and getting bigger or a claim coming forward. So I think I don't need to persuade anybody on this call that actually it is growing. There's no doubt about that. Lots of reasons for that, some of which I'm sure you will know yourself. Nobody fights over an estate with no money in it, for starts. So the reality is that large estates, life-changing amounts of money passing from this wealthiest generation in history, passing to the next one, is going to make a difference. There's no doubt about that. And what I'm seeing at our end is the sort of evolution of the reasoning behind claims, or the necessity to bring them, slightly changing. Because when I first started, it was more about people hoping or anticipating or even expecting an inheritance of some sort. And that's not new, as we know. You know, the Wills Act is a Victorian creation. And if you go back to Victorian times, there were people living off an inheritance even before people died back then. So it's not new that people were looking to an inheritance coming through. People always have. But I think what's changed now is that instead of it just being a hope, it seems to me to be more of a reliance. So I am absolutely relying on this to fund either retirement or fund debt. And this reliance, and there's surveys that's been done with this and studies, is putting it at 1 in 3. So 1 in 3 of us are relying on an inheritance to fund either debt or fund retirement. And of course, if you don't receive it and you're relying on it, very often you don't have a plan B. So you're left then in a situation where you have to bring a claim. And in fact, the same survey report comes back and says 1 in 4 say they will bring a claim if that actually happens. None of that's to do with merits, of course. That's just simply to do with reliance. So what we find at the contentious probate end is that by the time they get to us, their simple question is, I need to challenge this situation because I'm not happy with it, invariably because I've either not received what I need, or there's been some form of injustice, or both. And again, most contentious probate lawyers will do the same thing, is you will go through a consideration of, well, is there a probate claim that will take the will out and change the result in some way? If that doesn't succeed, or in addition, can I look to see if there's scope for a claim under the 1975 Act for increased provision in relation to the inheritance? Can I argue that I should have got more in circumstances? If I can't do that, then what's the next rung down? Well, can I look at equity? Can I look at some form of fair play to suggest that I'm in the right place and I can actually make a claim and get something back because a promise was made in some way, shape, or form? And then even below that, then what you get is, if you can't find any of those things, people start to scratch around and start to analyze things like payments made in life. Is that, well, my sibling got paid X and I didn't receive the same, and therefore that X must be a loan and therefore must be repaid. And you get into that kind of lifetime dispute. So I think that's what I'm seeing more of, is this idea that I just want to do something about it. Can I do it? And then you're going through the shopping list of potential claims to put it right. What I'm also seeing is that, whilst I wouldn't describe it as a tsunami building up, is that there are a few things that are now starting to come through that we are going to see more of, just as a matter of mathematics and odds. And one is that, well, first of all, people didn't start getting remarried and divorced until the sort of late 60s, early 70s. So as a result, those second marriages are the ones invariably that provide a dynamic that causes a problem that ends up with us being involved. And that dynamic is something that's occurring every year more frequently. So as a matter of statistics, you are going to get more people with blended families, as the Americans call it, that are going to give rise to potential problems, particularly where the children are significantly different in age from each side of the first marriages. So that's happening. I think also the other thing that's happening is we did a survey about 4 or 5 years ago now about Lark versus Nugas requests, and I did this across the entire probate administration spectrum of different sizes of different organisations, asking a series of questions. But one of those questions was, what is the average time period that passes between a Lark versus Nugas request and the actual will that it relates to? How long is it between you get from 1, which is making the will, to 2, a claim first coming in? And have a guess yourself, I won't test you, but what was the average time period for that? I'll count to 10. And the answer to that is we found it was 8 was the average. So 8 years was the average between that. Again, statistically, what was happening 8 years ago in our sector that was different, that was new, that changed, that may give rise to some problems going forward? And the answer to that is very simple, is that online wills are something that started round about 7 or 8 years ago in earnest, and they're increasing in number. So what we're finding now is, particularly Lark versus Nugas in different ways, is that the claims are now involving online wills. Now, I'm not suggesting for a second that online wills are unsafe. What I am saying is that they will become part of the strategy of looking to challenge a will when somebody is the 1 in 3 relying on a particular inheritance to fund the rest of their lives. They will look to see, how was that online will done, what checks were taken, etc., etc. So I can see that happening and coming down the line. A little bit of a crime watch rain check at this point, before we all get too depressed by it all, is that the sector we operate in is disparate, as you know, and at times quite desperate. But it's worth looking at a few statistics. There's 500,000 deaths a year, 150,000 grants. The highest sort of volume of grants in one organisation is the co-op, and they process and get through somewhere between 7,000 and 8,000 grants a year. The next biggest organisation is 2,000 grants per year. So you can see that if your biggest provider of probate administration services is only 5% of the actual number of grants, you get some idea of the length and of the tail of the incidence of people dealing with grants of probate. And only 10% of those are estates, in our experience, a maximum 10%, have some kind of dispute that causes a problem that we or people like us need to get involved in. So you're talking about anywhere between 5 and 10% of all those estates in a very widely spread number of organisations dealing with estate administrations. And that's not even looking at the 40, 50% who are doing it DIY themselves to the best of their ability. So in terms of the market and the opportunity, it's there, it's rising. We need to be aware of it. We're running a business on the back of it. You guys who are creating estate planning, you need to be able to make sure that you are aware of those changes coming down the line, because invariably it's not today, it's not tomorrow, it's sort of 8 years hence. They're the cases you're working on. There'll be other ones where they come to you with a dispute, a problem, or an issue, and knowing A, where do I put it, and B, in a commercial sense, how do we look at making some fees whilst we're assisting people? Because what we've done here is that we work on essentially a win-win-win basis. Is that in my view, and I've been doing it a long time, something is successful as a business if whatever we do comes out with 3 wins. And the primary win is always a client, because without the clients, you haven't got a business. So from the client's point of view, it needs to work for them. The second win needs to be for those businesses that are referring in to us. So the referrers or the sources of that work, are we looking after them? Are we making sure that we are helping them do what they do, but also commercially make sure we look after them? And then the third win is IDL Law itself, is that we need to make sure that we are taking on cases where we know we can add value, that we can help with the client, that we can get paid for the job we do, and grow on the back of it. So this kind of win, which sounds really basic, but it's so important, this win-win-win. If one of those wins is missing, we won't do it. We gather in our contentious probate work, essentially, there are only 3 real sources anyway of this type of work. There is the direct source work, the D2C, if you like. There are the internal referrals that some contentious probate departments will get from their non-contentious departments that they work with. And then, of course, there is the B2B, the business-to-business recommendation and referral. So those are the 3 main sources that you can get work from. In fact, for anybody, those are the 3 sources getting work from. What we do at IDR, what makes us different, and to be honest, the reason why we're still the only firm that just does this and nothing else, is that we do use a combination of B2B and D2C, but the B2B work and the referrals we get accounts for over 90% of all of our cases. So that marketing funnel is very, very wide, but it's very, very focused. We only do this, so we only look at improving what we can do to make sure that win-win-win succeeds. The IDRN, many of you are members of that, we've now got just short between 900 and 1,000 subscribers. In the last 12 months, we've received referrals from over 200 different organisations. Most will send 1, 2, 3 a year, but if you've got enough of them, that's a lot of work coming through. Because we work on a win-win-win, we've tried to then take a step back as a firm and say, look, we are uniquely positioned in our market where we don't need to consider other types of law. We don't need to consider other ways of working. For those of you who do contentious probate, you'll know is that the biggest challenge for contentious probate teams is actually manage the interface between them and the rest of their practice with respect to how cases are funded, because the vast majority of clients will try and look for some kind of deferred or contingent arrangement. So what happens is that the law firm ends up bankrolling those particular departments whilst they're collecting their cash at the end of it. And unless you've got a model that enables pay-as-you-go as a far greater incidence, then it becomes very difficult to kick out and start on your own, which is why it doesn't happen. So, but what we've tried to do is try and use our unique position in the market and say, right, okay, how can we do what we do better to resolve contentious probate work in a way that's win-win-win? And that's what we call our mainstay. So resolving disputes is our mainstay. The second bit is, how do we help people? How do we take what we know from the sharp back end, where it's actually dealing with the disputes, seeing the upset, working through to mediation? Of the 7,000 inquiries we've had 3 trials, give you some idea. Very, very hot on mediation. We've just launched our own mediation service, really keen on doing that. And we do that by leading cases. We'll take the case by the scruff of the neck usually and push it towards a negotiated settlement. Thankfully, there are quite a few lawyers and some on this call who do exactly the same. So getting to a settlement is a little bit easier. But what have we learned and what can we pass back to those that are helping the very people that we can't talk to, because our best witness is always dead, is how do we push that back, what we know, to help them to educate and avoid contentious probate? That's a win for the client. It's a win for the estate planner because they're in a position where they can provide best advice. But what we could do is equally make that commercially viable. So is there a way of doing this that makes it commercially viable for the estate planners to take the steps that we are recommending? And I'll run through those in a minute. And the short answer is we think we can. And the win for IDR is that we're always going to be busy. If there's always contentious probate coming through, we're not resting on our laurels, but the market is such and our position is such, we're always very busy. So if I can look back, and it's a little bit of a legacy point for me, I suppose, is looking back and think, actually, we can do this. We can actually stop the volume of cases coming through or help it happen. Then I have to say, I would retire in X number of years' time, a much happier man. So that's the idea. In terms of, I'm just going to flip through 2. I know I'm conscious of time. I've probably got about 15 minutes. I'm going to spend about 10, I'm going to say 10 minutes on each. That kind of flies in the face of my maths level. Is I'm going to do 7.5 minutes on each. I'm going to do a little bit about avoiding contentious probate and the fee opportunities. And then I'm going to do a bit on resolving contentious probate, how we do that, how we help you do that, and where the fee opportunities are for you on that as well. So hopefully that makes sense. So firstly, avoiding contentious probate. So this is the bit where we've taken what we've learned, brought it back in time and said, right, okay, let's apply that here. Now, and this comes from not just from the experience of doing disputes, this comes from speaking with our referrers. Again, unique position because virtually all our work comes from organisations that are doing this type of work. How do we help you do that? And that's how the IDRN was born, to be honest, is that because we had such a wide net of people to reach and contact and is we created the IDRN, and the IDRN fulfills the first thing we're doing, which is the education and the support. So it's the education and support for people who are dealing with estate planning where they take a view or should be aware that there are claims and problems a bit further down the line. So for example, in the IDRN, there are education pieces about things like intestacy claims, things like 1975 Act claims, who can bring a claim, who can't bring a claim, how do you see it coming down the tracks? Fundamentally, anybody who regularly looks after individuals in their estate planning will have a spidey sense, a gut sense, a human empathetic sense of when there may well be trouble ahead. You will see it before anybody else, I suspect, because there will be a quietening of instruction, shall we say, when he starts to talk about what relationship somebody has, or there's a child missing, or I'm leaving out my cohabitee of 15 years because. You will see these things cropping up. And yes, it's quite right. And I've given lectures before on Larkin-Nugas and the like about keeping track of notes and reasonings and taking statements. That type of stuff is super important. And I would reinforce anybody who's telling you to do that. What I'm really keen to do is 2 things. One is you only know what you know. So you only know the bits that you've come across or the bits that you've learned. And we're all the same. What we've got to try and do, and what hopefully we do at no cost to everybody that's registered in the IDRN, is provide and widen that knowledge net of, oh, okay, I didn't know that. Or, I've got a universal wealth case where the situation is that they've come in to me to make new plans, but they've got an existing will or a lifetime trust that's being set up with universal wealth. I don't know what to do about this because it's terrible, but can we take steps to do something about it? And the short answer is yes, you can. Is that we've been involved in a couple of reported cases on universal wealth, so much so that there's if you take away nothing from this talk, go and have a listen to Mr. Wade, Roger Wade's interview and discussion on the IDRN in the universal wealth section, because it's a really good listen. And he's super sort of northern bloke who is really down to earth and explains how the universal wealth con happened. And that's basically he was one of our 2 clients that we took all the way and got a result. So it's this kind of idea of you don't know what you don't know, so therefore we'll try and educate you and expand that. We've taken a little bit further into proactive, and this is something, giving and going away a little bit, is that we're launching something a little bit later in the year. One of the advantages about private equity and being exclusively contentious probate is that you've got a combination of the finance to do it together with the desire and the headroom to do it. Is that we've created what would we call something like, the provisional name now is IDR Protect. Is that IDR Protect is a group of apps that we think drops into the armory of anybody who's doing any estate planning. It's not a substitute for human empathetic and knowledge assessment, but what it is it's a formulaic, recordable method of tracking what's happening at the time a will is made. It sounds very cryptic, doesn't it? But it does all of those things, but it also then looks to, for example, if there's been a lifetime gift that has been made by your clients, and we've identified 19 different problems that may arise or could occur in relation to a lifetime gift, for example. So I'm not going to ask you to try and all name 19. It took a few of us, but once you've got to the 19, what this particular app does is deals with that and makes sure that you and your case is put in good order and the clients are in a much stronger position. Because my view is if 2/3 of people are still not making a will, then the ones that actually get up and do it, we should be protecting them as best we can to keep these wills in place. We all know that the court, well, perhaps we don't, the courts aren't particularly enamored of overturning wills. You know, however much you read about it, is they prefer to keep them than get rid of them. There's no doubt about that. And the burden of proof invariably is usually on the person that's asserting to try and knock it out. Not always, but in most cases. So anything we can do to protect works quite cleverly. Now, in respect of win-win-win, in terms of fee opportunities, is if we can create that in a way that provides these answers, this backup, in a way that is really easily to do and to follow, that provides at a charge out to the client who's making the will. So it's an extra charge, but it's a small fee that can be recharged by you. You're the one that's actually organising the estate planning, and it goes out with your name on because we white label it. Then we're suddenly getting into a win-win territory. From our point of view, it will be a volume type of thing rather than a full-on dispute. But of course, if those things then become disputed, we're already in situ to help out because we were part of the actual preparation. So I give you some idea, and you'll hear more about this from the IDRN updates. So you'll see this coming over the hill fairly soon. So if you keep your eye out from IDR Protect, that will give you an idea of where it's coming from. If you want a flavour of it, have a look at LARK Online. That's currently live, which is LARKE online.co.uk, and that will give you a flavour. That's ours, by the way, which we set up, and that just deals with execution. But we are looking with some other partners to work in some mental capacity assessments in there as well. So a really interesting kind of space for us. And I was in a talk yesterday, and one of the attendees messaged me afterwards with a problem, which is I don't know what to do here, because morally I'm a little bit sixes and sevens as to what to do. Is I acted for this couple who were on second marriages, or it was a second marriage, and they had children from previous, and it was a classic mirror will, is that give everything to the survivor, and then both agreed to then share it out between all 4 children, 2 on both sides, on second death. And you can guess what happens, because it's not unusual, is that she gets the survivor coming back in and asking her to execute a new will, change it round because that person has lost contact, fallen out with the other two, and wants to make sure that just their two children should benefit from the whole combined estate. Now, it's not a mutual will, and it is a mirror will, but her dilemma was both legal and also moral. Is that moral? She was, I don't think I can do this, because it was very clear from both of them that they wanted to set this up on the basis that the second, on first death, the second would benefit, and on second death, everybody would benefit equally in the children. So we ran through that. But again, it gives you an example of and what she was worried about, and she's right to be, is that particular file. If she then did that will, she's already going to be asked about the first will if it's ever challenged by the other children. She's already going to be asked about what she did next and why there was a delay and a dilemma. So she's almost getting to a situation where the advice, and it won't surprise you, is the advice was, I would probably step away from it if you can. But it gives you some idea of these kind of phone calls that we're now starting to get in life, and we encourage that, because if we're only converting 21% of inquiries, they're the ones that we want, is the rest of them are still being dealt with. They are still pushed out, and people are looked after. And in fact, our NPS score for clients across that entire cohort, so not just the ones we're taking in, but everybody, still sits at 88, which if you look up the NPS scores, you'll know how good that and strong that is. The average law firm is 35, for example. So that's how we deal with avoiding contentious probate. It's a combination of education and support, along with what we think will be some really helpful protective tools. The education support comes at no cost. You've just got to register, and we tell you everything else. The IDR Protect is something that won't cost you anything. It'd be charged out every time it's used at a small fee, which you can then recharge out to your client. I love no-brainers, and to us, it's something that's so straightforward and makes sense that there is nothing to lose. So that's the first half. So that's the thing we brought back to avoiding contentious probate and fee opportunities there. The next one is okay, it's happened, someone's died, a claim has come in. How do we deal, and what are the fee opportunities with resolving contentious probate? Now that, as I said before, is our mainstay. Our mainstay of work involves that. The fee earners, the legal team that we've got, are all geared towards resolution of disputes. It's in the title, IDR law. So that's really where we feel very comfortable doing it, but we want to IDR it. We want to make sure that we do this in a way that sits well with our referrers and also our clients. So in terms of our triage team is accessible to every source of inquiry. So we get inquiries coming in from the IDRM, which is probably the easiest way to do it. There's a little refer a client button that comes in. We get it coming through from claim check, which I'll talk about in a minute. We get it coming through from phone calls, from emails. It really doesn't matter where it comes from or how it gets to us, is that when it lands in the triage center, it is triaged. And the whole point behind that is that the first phone call they will get from us, and it's usually same day, is a, how are you? This sounds like you're having a rough time. Not, can I talk to you about section 116 or section 50? Let's see where we're going to go with it. We talk, and the triage team are actually trained social workers, but they look after the clients, gather the information we need, which fed into the CRM and the case management system, which we spent the last 10 months building. So that drops in there, and then it goes through to the legal team, who pick up the work, and then they will actually contact the client and push it on. At all stages, we are giving information to the client. We do not raise any fees until we've got an inquiry all the way through to retainer. And at the retainer point, we have already split down whatever the objective is, because that's something different we do. In terms of objectives on retainers, what we don't do, again, is say, you have instructed us to take an application on section 50 or one, whatever it is. We actually say, what is it in real terms that you want? And it could be something as simple as, and we have said this, is that I don't want my sister to get anything. And it could be as simple as that, because that's how they measure us, not against whether we succeeded at section 50, whatever. It's about, did you succeed in the objective that we're actually trying to achieve? And we take that objective and we set out a list then of phases and minimum maximum fee estimates, which are then kept live as we're going through. So that's the win for the client. So we're confident that we're very transparent. We are ahead of the game to some extent. We are specialists. We don't do anything else, and we get good results. We've not lost a trial to date, touch wood. So and that's because we don't go to trial unless we're never going to win. So that's the way it works. So we, importantly, in terms of fees and opportunities, is that we work, because we don't have a non-contentious team, we don't compete, we don't take the clients away, we actually work with you. So if you're doing an estate administration, we will work alongside you. So we will ask you if you can carry on with the bits that can be done. You keep your relationship with your client. And when we finish that bit, we just hand them back to you for the estate then to be completely administered. There is no risk at all of your client going somewhere else. They will stay with you. If you are a will writer or estate planner that doesn't do probate administrations, but you use an organization and you refer your work through, then if you get them to refer to us, most do anyway, to be fair, but if you push those through, then again, we will give credit back to where it came from. So it's again a win-win-win situation. The clients get the great service. You know that if it's come through to us, your name, your label, your referral code is kept with it. So that means two things. If a client's happy to do this, we can keep you updated. And in any event, what we do is anybody that refers anything to us, we have open a 10% fee share agreement if that's of interest. Some people do, some people don't. But what is consistent is once a month you will get your referrer pack, which will come out listing the inquiries that have come through to us, the result of those inquiries, which cases have been taken on, and then it's a running database of cases running with an idea of what the 10% fee share equates to for you as you're going through it. And if there's any cases finished, we ask you to invoice us for the fee share that has been calculated. So you're always kept in the loop, and that's the idea, is that every month it's a win-win-win, is that everybody's working in the same direction. What we've tried to do beyond that is to say, well, okay, our numbers are getting higher and higher. 7,000 inquiries across a 6-year period is a lot. As we grow, it's obviously getting higher. So we're getting busier and busier at the front end. The 21% bizarrely stays about the same across the board. And that continues. So that will work, but we are very alive to the fact that there are probably 30–40% of referrals where the legal team doesn't even need to see it at all. So we need to build ways, and this is where the future is for us, is that we've got AI coming into our triaging part of the business. We built something called the claim checker. Now the claim checker is currently in version 2. It's just launched V2. V1 was sat on the IDRN, and V2 now sits on the actual IDRN itself. And you can access it by just being a member of the IDRN. And what does it do? It takes you through a series of questions about your case. It's designed to be aimed at the claimant, but the defendant can still use it. Is you go through and it will give you a yes, no, or a maybe answer to the question, can I do something about this situation? So it's giving an online 24/7 way of triaging a claim coming in. This is V2. I've got no doubt by 12 months' time, V3, V4 and it will keep developing and moving on. The good thing and the clever thing, and this is because Lindsay's done it, is that it talks to the claim checker, talks to our CRM system, which talks to our referral packs, which talks to you, so it's a full circle. So what you will find in your monthly reports is that you will be able to see what's come through and how it was referred to us. Why is that important? Because what we've done with the claim checker V2 is we've made it in a widget format. It means that it can be dropped on any website and it can be white labeled. And what happens is if anybody attends on your website, goes through it, it kicks through to us with your website and your name, your code on it, and it goes directly into our triage hopper and is dealt with in the usual way. So what that means is that those people who are using the Claim Checker V2 on their own websites can generate passive income coming through without actually even speaking to the clients at all. But of course, if it comes from you and it needs an administration, and this is where our unique position is that we can pass it back to you because we don't do it. So as soon as the case is finished, we have to pass it back from whence it came. So it will go back to you. So this is how we're dealing with this resolving of contentious probate, sort of in a way that presents itself with fee opportunities, is to get the inquiries to us early. If I can give you again 2 or 3 takeaways, is the earlier we get hold of it, the easier it is to resolve the dispute. It just is. And what we do find is lots of firms, well-meaning, non-contentious probate lawyers who have very good relationships with their clients, and very accountants do this actually quite a lot as well, is that they try and they stay involved just that bit too long. So their motives are absolutely genuine. They want to bring the parties together. They almost want to act as mediators. So they want to get to a position where everybody's happy, but very quickly you get yourself in a mess. And if you're not careful, you'll end up losing the entire family because you'll end up being conflicted, them going to different lawyers on both sides and moving away. Far better that you get us involved earlier. Let us do what we do and you do what you do. And because those lines are clearly marked, because we don't do anything else, is that we've never had a problem recovering fees going forward. So that's the combination. Get it to us early, get yourself on the triage system and the IDRN. Claim checker V2 is the direction of travel. It is. We've also got a B2C or a D2C version that kicks out again a little bit later on in the year. But all these things will become exciting launches. You might see me again talking about them later on in the year. So please do keep your eye on the IDRN and the updates that come out every month. If you've got any cases at all, any problems, issues, questions, feel free to give us a shout, and we will do absolutely our best to answer those straight away. Our triage team is well, we've got 4 people coming in, so it's normally 24 hours maximum. The triage team will still speak to every referral coming in, but our legal team is about at 2 days now before we can get back to you because of the level of work we've got. But it's coming through, and we've got team members arriving. If you are interested in having a conversation with me about that as well, give me a shout. If you are interested in looking at careers and going beyond, I'm not going to miss an opportunity not to put that invitation out. So more than happy to have a chat with anybody. So it's 12:45, so I promised I would stop at that stage. It's my chosen specialist subject, you've probably gathered. It's I get very enthusiastic about it, so I do apologise if that comes across a little bit excessively, but I do believe it's something we need to do, and we're doing it in a way that I think makes a difference. So on that note, I'm going to try not to take offence at the various lists I'm getting here on the blimey. So we've got, I don't know if anybody can see the list of in the.
There's absolutely loads in there, Martin.
Oh my word! So we've got. All right, we're going to go through these. We've got a flight. I'm going to say these out, and then corrected to fight. Old lawyer, I like that. A patience. That has to come from a contentious probate. Yes, it does, Chris. Thank you. Without just can't get a controversial murder. Wow. There's a story to tell behind that one, I think. I'm not going to try and pronounce that, but I like it, Ivan. A coven of probate lawyers. Wow. Magic is sometimes needed. A quibble, right? A clawsome. Alliteration as well. A disputation. Very good. A Jarndyce. Wow. Somebody, Chris, should have known that, well read. Bit of interest. Jarndyce, as everyone knows, Bleak House is what is astonishing, sometimes we forget this, is that Bleak House is actually written after the Wills Act came out. That's how old that piece of legislation is. Blast from past lawyers, a disagreement of a psychic of contentious probate lawyers. I have had cases, Steve, where I've gone into the other room and in a mediation, invited, by the way, sat down, and the opponents have got family of 3, and they had a photograph of the deceased with a candle in front of it actually on the table with them, which I thought it was a lovely reminder of who it was all about. But it wasn't that. It was actually they were connecting with them to try and get instructions as to what to do. So I beat a hasty retreat because I couldn't help with that. A pride of probate lawyers, I quite like that. A mediators, Simon Brown, lovely. Pragmatist Larkline, Air Fight Club, Cluster of Bluster, Angus Houston, shame on you. I hope you're going to the game tomorrow, on Saturday, rather. Legacy Shrinks. Do you know, they're all really good. That's probably the best I've had for a while. I'm going to go on the prize. I'm going to go for a Jarndyce just because I'm going to go for a Jarndyce. Jarndyce or Jarndyce? I'll go for a Jarndyce. Well done, Chris. So we'll do that. But thank you for everybody taking part in those. Is there any questions that you want to drop on there that anybody's got? I don't mind talking about the sector generally. I don't mind talking about things that I've mentioned here. I would say that if you want to find out more about CCV2 or the Claim Checker version 2, please do just ask for a tour. It can come as part of the IDRN tour. I know Lindsay will put the contact details up there. We do have one other little bit of tech that's rolling out, which I'll just drop, and you can make a decision as to whether or not you want to have a chat with me about it. It's something called iDivide, which is a perceived fairness algorithm. We got a beta version of it, and the idea behind it is it helps people who are arguing about the contents of a house divide it between them. And it was a mathematical algorithm designed and built by a mediator called Martin Plowman, if people know him. His wife, very clever maths professor, and she created this algorithm. And what it does is it takes a known number of people with a known number of items and gets them to bid with a certain number of beans they get each. And then it takes that data and applies perceived fairness algorithm theories. And what it does is it produces a list of, you get this, you get that, and you get the other. And what's astonishing is when we did the tests of it, is that in every single case, every single person was happy with the distribution. Don't ask me how it works. It does work. And we're, as I say, we're beta testing it as to the best way to bring it to the market, and the best way to monetize, I suppose, is to give it some reach so that people can stop fighting about chattels in mediation, which for anybody that's attended a mediation would tell you is, if it gets raised at the last minute, you just groan inside, because you know that the emotions connected to things are so great that it can just push you way beyond the time limits that you were hoping you'd get home for your dinner. It's not going to happen. So hopefully that is of help and interest. Any questions at all, do fire it through. I've just seen here that Lindsay's responded by saying, yes, there is a recording of today's session. If there's nothing else from anybody else, Lindsay, I think...
No, I think
you've heard enough from me, I suspect.